By way of a brief historical background, London maritime arbitration dates back as far as the mid-17th century, when trade was negotiated in coffee houses and thereafter at the Baltic Exchange. In early times, maritime disputes were resolved by experienced shipbrokers, chosen by the litigating parties. This had the benefit of speed, informality to the process, and of course confidentiality, which today's arbitration still maintains, and which prevented any reputational damage which could potentially come to the losing party. So an amicable process which worked relatively well. Costs, of course, were of little concern because lawyers played no role. Under English law, unlike the position under most international systems of arbitration, there's no requirement for arbitrators to be independent unless the arbitration agreement incorporates a requirement for the same. In maritime arbitration, a commercial arbitrator is commonly selected by one of the parties from personal knowledge or acquaintance. Due to the limited pool of specialist maritime arbitrators, it's generally considered in the shipping market acceptable for a party to have a continuing repeat relationship with an arbitrator it appoints, or for an arbitrator to be appointed frequently by ship owners or charterers, who are the most common generic parties in shipping disputes. Now, focusing on the impartiality requirement in section 24(1)(a), and whether an arbitrator could, without disclosure, accept appointments. The essence of the case was whether the arbitrator could, without disclosure, accept appointments in multiple references concerning overlapping subject matter with only one common party, without thereby giving rise to an appearance of bias. It was never asserted in the Halliburton case that the arbitrator had in fact been biased or committed any deliberate wrongdoing, but rather that he'd created an appearance of bias.